and thank you for joining us today for a one-hour webinar on Hitting New Roads, Prevailing Trends in Consumer Product Litigation. My name is Neil Walters, and I'm a partner at the law firm of Ballard Spahr. Focus my practice on the defense of product liability matters, including counseling, as well as the defense of consumer product class actions. Thank you for joining us. We have a nice national audience today for this important topic. If you have any questions during the hour, please put them into the chat box, and we'll do our best to answer them. I'm privileged to have worked closely with several of the panelists who will talk about consumer product class action litigation today. In developing this panel, we all agreed that it was important to focus a little bit more on the practical aspects of such cases. With this in mind, we have a panel, a lawyer who defends consumer class actions every day. Mike Carroll is a rising star at Ballard Spahr, who is a part of a trial team that has defended 2 class actions through full verdicts. In former life, he was an associate who helped defend Merck in the Vox trials here in New Jersey. We're all thrilled to have Dr. Bruce Strombaum join us from Los Angeles today. Dr. Strombaum is an expert who handles sophisticated economic damages issues in consumer product cases. The doctor and I have worked together in successfully defending 2 consumer product class actions with significant economic damages allegations. And certainly not least, we're pleased that my partner, retired New Jersey Supreme Court Justice Roberto Rivera-Soto, is joining us. Justice Rivera will give us a unique view on appellate issues that arise in consumer product class actions. Before I turn over the presentation, let me very briefly give you an overview of what we're going to talk about today. We're going to start with prevailing trends in consumer product class actions, the issues that frequently are arising with respect to motor vehicles, pharmaceuticals, medical devices, and consumer products of all types, both in terms of practice and the substance of the doctrine that is developing to help litigate these cases. We'll turn to a practical look at the economic damages issues that can arise in those consumer product class actions. And Dr. Strombaum will talk about that. And last but not least, Rivera will talk about issues, including the interesting issue of how decertification of classes in consumer product cases has evolved and has changed. So with that said, I'm pleased to introduce Mike Carroll.
Thanks, Neil. So I think it's important to provide a little bit of background and context for the discussion today. And I think the easiest way to do that is figure out first how we got here. And we're focused today really with consumer product class actions based on state consumer protection statutes that I think we're all familiar with. And that really begins in the 1960s and 70s with calls for real legislative rebalancing of the relationship between companies and consumers, based on a public perception, at least, that the pendulum has swung too far in favor of companies. So that legislative rebalancing takes place in the states who begin to enact consumer protection statutes that tended to function as essentially and have been referred to as little FTC acts, sort of supplementing the FTC's mission to protect consumers from unfair practices. And in their original form, they're designed to enable attorneys general to enjoin unfair trade practices and in some cases seek restitution. Of course, they've all been amended at long last Iowa in 2009 to provide private rights of action, including class actions. Those private rights of action under the state consumer protection statutes do not include a number of the traditional elements that the common law claims that attorneys general and private consumers had to rely on to bring their claims. Elements like reliance on advertising or privity of contract. And that's intentional because the goal was to enact broad remedial legislation to protect consumers. And courts have taken their marching orders from that legislative intent and interpreted the statutes very, very broadly. And so what follows is a couple of decades of fairly expansive interpretations with really intentionally ill-defined standards. And the result, of course, is expansive litigation that, frankly, is unrelated to its original purpose. In fact, one recent review of this by some professors at George Mason University took a look at these consumer product class actions to see to what extent the allegedly unfair trade practices would be violations of the federal FTC Act, and surprisingly, very few of them qualified. First, there are a lot of targets for enterprising class counsel because they really can take any product that has any sort of advertising and can fail to live up to any of numerous consumer expectations and find in that a good multiplier: automobiles, electronics, appliances, foods, medical devices, pharmaceuticals. Large damages are not required because if you get a million class members with small damages, that's enough to justify substantial attorney's fees. Consumer product companies are particularly attractive in these class action litigation because you have mass distribution of an identical product that is accompanied largely by identical advertising, not necessarily over time, and that creates an attractive return on class counsel's investment. When they get into discovery, particularly with regulated products or products that have significant warranty programs, such as automobiles, those robust warranty programs and the regulatory reporting requirements result in a fair amount of data available to these class counsel that kind of does their homework for them on showing product performance issues, complaints for customers, service records, and the like. And thirdly, with consumer products, particularly in the warranty context, are opportunities for settlements that have a significant non-monetary relief component, such as extending a warranty or issuing discounts on future purchases that allow a settlement because the defendant doesn't have to outlay cash per se, but allows class counsel to creatively value the settlement to support a substantial fee. So all of these together make consumer product companies prime targets for class lawyers looking for an easy return on their investment. As we defense lawyers are fond of pointing out, there is substantial variability among various states' consumer protection statutes. But the basic elements of the consumer product claim, of course, are an unlawful or unfair trade practice, which is the genesis of the part of the statute, which would be a material misrepresentation about what the product can do. More often, it's an alleged omission about a product defect or a limitation. Carry reliance requirement, many do not, but they still have a causation requirement that allows defense practitioners to sort of get at the reliance issue through causation. But this is the most contested element in consumer product class actions because, of course, this is where we focus our efforts of establishing individualized issues, and plaintiffs' counsel try to focus their efforts on picking over the individualized issues, usually with, I think, what we can generously call creative expert testimony. And then, of course, there has to be damages, some type of ascertainable loss that the court can determine and assign value to. Fortunately, the federal courts and Congress rescue try to rein in what had become fairly substantial abuse of the class action vehicle. And before switching very briefly to the Class Action Fairness Act, it's important to know 23F, which was an important tool in reining in class action abuse because it allowed federal appellate courts to step in at the class certification stage instead of requiring a case to continue to completion to address the concerns of either party. And interestingly, Rule 23F allows either party to appeal a class certification decision or seek appeal of a class certification decision to a federal appellate court. And the rule was written intentionally to be neutral, the idea being that both sides could certainly be offended by an adverse certification decision and may want to seek relief. In practice, a very recent study, in fact, from last month, I was in Clark Law School, and I can send the site to anybody who'd like it. It's going to be published in a forthcoming issued Washington University Law Review, did an in-depth review of class actions, and one of the things they looked at was how effective Rule 23F has been for both sides. And turns out, perhaps not surprisingly, despite its intended neutrality, it has been far, far beneficial to defendants. Of approximately 170 23F appeals that have been granted since the rule was implemented, 70% of those appeals were brought by defendants. Defendants won 71% of those appeals. And then, of course, 23F only applies to federal class actions, so the Class Action Fairness Act in 2005 brought most class actions into federal court. And what that's really resulted in, and what we're going to focus on for the next few minutes, is the substantial body of federal case law, particularly since the implementation of CAFA, that has resulted. And the prevailing trends, particularly rigorous analysis, which came about 30 years ago, but of course Dukes has refocused our attention to it. The application of Daubert at the class certification stage, arbitration provisions, standing, and aggregate damages. Rigorous analysis, of course, is an issue that's been debated, for Dukes at least, for 30 years because of an inherent conflict between two Supreme Court opinions. The infamous Eisen case, of course, yielded one of the most cited pieces of dicta from the Supreme Court in its history, which, of course, was the language from Eisen in 1974, where the Supreme Court said, "We find nothing in either the language or history of Rule 23 that gives a court any authority to conduct a preliminary inquiry into the merits of a suit in order to determine whether it may be maintained class action." Lower courts took this as guidance that they weren't to touch the merits until after the class certification decision, despite the fact that a few years later in the Falcon decision, the Supreme Court said it may be necessary to probe behind the pleadings, and the court said class actions may only be certified if the trial court is satisfied after a rigorous analysis that the prerequisites of Rule 23A have been satisfied. So that's the introduction of rigorous analysis. Because of Eisen and the ensuing circuit court confusion that followed it, there was a lot of confusion as to how to level district court judges could probe into the merits in order to decide if a class should be certified. And fortunately, by the time Dukes rolls around, a lot of circuit courts, here in the Third Circuit we have per side, but we're not alone, that realized that Eisen really was being misconstrued because, of course, that case had to do with shifting costs to defendants for class notice and the like, and really nothing to do with the merits of plaintiff's case and how it impacts class certification. Comes along and confirms rigorous analysis is required and, of course, may require a review of the merits to the extent it goes to class certification. It also revived the commonality element. Of course, commonality under 23A had become a passing reference for most district court judges. Anything that defendants tried to focus on in commonality was usually pushed to the predominance analysis. And, of course, that meant that commonality was skipped over, and predominance isn't part of B1 and B2 classes. And so it's really significant, frankly, that in Dukes, we talk a lot about rigorous analysis, but what they did was revive commonality, and they did it in a very important way. They said what matters to class certification is not the raising of common questions, even in droves, but the capacity of a class-wide proceeding to generate common answers to drive the resolution of the litigation. And it matters because, of course, we're all familiar with the common class action complaint that has a laundry list of questions, but offers very few answers. And, of course, there was also a nod in support of Daubert, where the district court had concluded that Daubert did not apply to expert testimony at class cert stage, and the Supreme Court said, quote, "We doubt that this is so." So what is the impact of all this? Well, it has a strategic impact for practitioners throughout the entirety of the pre-certification stage of litigation. Duke, and here in the Third Circuit, Peroxide, and certainly the other circuits have their counterpart, naturally with Twombly and Iqbal, support more detailed scrutiny starting right at the pleadings and moving all the way through class certification. Courts are showing more of a willingness to scrutinize heavily the pleadings, scrutinize heavily the certification motion. Motions to dismiss and motions to strike are being granted with more frequency, whether it be insufficient pleadings. I have one example here, the Albin versus BMW case, which is the District of New Jersey, where plaintiffs alleged, the named plaintiff alleged a foul odor emanating from his BMW. And the judge ultimately dismissed it under a 9B, heightened pleading standard analysis, which applies to these consumer fraud claims, of course, saying that it's not enough to allege the manufacturer knew a part might fail. Rather, the plaintiff must sufficiently allege that a defendant manufacturer knew with certainty a component would fail within the warranty period. Allow plaintiffs to assert that a part might fail and that a defendant knew a part might fail effectively removes the center element of the consumer fraud claim. We're also seeing it in the class context. There's now a robust body of law on choice of law. Courts, particularly if they apply the most significant context test of the restatement, that says the law of the home state applies. That is where the consumer purchased the product, relied on any representations about the product, used the product, and it is the state in which the product failed. And those challenges with more frequency are overcoming plaintiff's argument that, well, all the decisions were made in the defendant's home state. The recent OnStar decision out of the Eastern District of Michigan is an excellent example of that. And lastly, motions to deny class certification. This is under the umbrella of, Dukes gives defendants coverage to be more aggressive. It needs to be done in the right case, but there's an excellent case I've cited here from the Ninth Circuit, where the Ninth Circuit, reviewing a district court's of a defendant's motion, where the defendant had moved to deny class certification, and the plaintiffs objected, saying, that's not how it works. We get to get the information we need, then we get to move for class certification. And the Ninth Circuit said that nothing in the plain language of Rule 23 either vests plaintiffs with the exclusive right to put the class certification issue before the district court, or prohibits a defendant from seeking early resolution of the class cert question. And that case is very useful because it has a relatively in-depth look at how other federal courts and circuits have handled it, finding that federal courts repeatedly have considered defendants' motions to deny classification. And sort of a practitioner note aside here, at any point in discovery where there is enough evidence that a court can look at the pleadings and whatever limited discovery has been conducted and decide that the elements of Rule 23 cannot be met, there is nothing preventing a defendant from placing that question before the court instead of waiting, as is more common. Rigorous analysis also impacts expert scrutiny. Not uncommon for traditionally to say we don't do a Daubert analysis at the class certification stage, and in fact that's still true in some districts. I've cited some examples here going either way. Probably the best recent pro-defense example is out of the Seventh Circuit in the American Honda Motor case, which was a motorcycle case where the plaintiff was complaining that there was too much wobble in the handling of the motorcycle, and their entire case hinged on an expert who had developed some sort of metric for measuring motorcycle wobble and what it should be and what it was on this particular Honda. And the district court in that case actually expressed great reservations about the expert's testimony and its reliability. In fact, the district court said the court has definite reservations about the reliability of Mr. Ezra's wobble decay standard. Nevertheless, the court declines to exclude the report at this early stage of the proceedings, and the Seventh Circuit reversed a class cert decision because full Daubert analysis was not done. Of course, the nod to that Daubert analysis in Dukes ought to encourage more circuits to adopt the kind of approach that the Seventh Circuit took in American Honda. And of course, the defense side, consumer behavior experts become critical because we're often dealing with complex products. The automobile is a great example. People buy automobiles for a lot of different reasons, some for safety, some for performance, for looks. And so a consumer behavior expert can identify for the court those issues. And of course, all of those are individual issues that impact the class certification decision. So what does it all mean? Well, the justice will be speaking a bit about what it means at the appellate level, but at the trial level, what it means for class certification is the initial decision. This is sort of you have to take the good with the bad. defendants have a lot of options for developing a more robust record to try to show the court that class cert is improper. Class cert should be denied, to scrutinize plaintiffs' experts. But of course, what this does is create a more substantial record to support a class certification decision. Bifurcation between class cert discovery and merits discovery will naturally become more difficult, if not disappear altogether, because it's hard as the defendant to say we should subject plaintiff's expert to a full Daubert analysis, but we don't have to give that expert the discovery he needs to render a Daubert-proof opinion. And decertification down the line may become more difficult because, of course, the traditional approach was you certify based on a limited record, and as the defendants, we will show you later why that was incorrect and you should decertify. And now with a fuller record up front, that becomes more difficult. Very briefly, arbitration is obviously a huge issue following the AT&T decision out of the Supreme Court. Consumer product and other companies, frankly, that have literature that includes contracts or arbitration provisions. There was a long-standing tension between the Federal Arbitration Act had a savings clause that essentially said class waiver provisions in arbitration contracts cannot be invalidated unless it is based on a ground that applies to all contracts. And in the AT&T decision, the Supreme Court famously came down in favor of the FAA in that tension. And any company that haven't since then revisited their literature, particularly their class waiver provisions, should do so. Lastly, probably the hot topic of the moment, because district courts, frankly, are struggling with how to apply it, issue of standing. And the key issue here in consumer product cases is exposure and manifestation. It is enough in most jurisdictions to simply have the existence of a defect. You have to be harmed by it. You have to have manifested the defect in your product, or if it's an unfair trade practice, advertising claim, for instance, you have seen the advertising. And this is less controversial, of course, with respect to named plaintiffs. Of course, the named plaintiff has to have seen the advertising. But there's substantial absent class member confusion. And I put a couple examples up here of what appears to be a developing circuit split on this issue. The circuit saying that plaintiffs, of course, cannot represent a class of persons who lack ability to bring the suit themselves. Frankly, that's a straight violation of the Rules Enabling Act. And then you have the Ninth Circuit saying standing is satisfied if at least one named plaintiff meets the requirement. And interestingly, just a month ago, it was in April, the Supreme Court denied cert in that Ticketmaster case. At the moment, I think what a lot of us are watching is the Toyota unintended acceleration case out in California, because there, the district judge denied a motion to dismiss on the standing issue, where in fact the named plaintiffs hadn't even manifested the alleged defect. And the issue is approximately 5,800, according to plaintiffs, approximately 5,800 purchasers have experienced unintended acceleration with their Toyota vehicles, and the class would include tens of millions of past and present vehicle owners. And so Toyota moved to dismiss, saying, they don't have standing, they haven't experienced the defect, and the district court said, but they didn't get the benefit of their bargain, which was a safe Toyota. It may someday manifest the defect. And so that is an unsafe vehicle. They didn't get the benefit of their bargain. And the district court at least realized that that was a relatively controversial position to find standing for plaintiffs who hadn't manifested the defect, and certified the issue to the Ninth Circuit. Briefing has just been filed. In light of the Ticketmaster decision, we shouldn't be too optimistic in the Ninth Circuit after all, but we'll see what happens. So as I transition here to the next speaker, the last issue I wanted to raise is aggregate damages. These are cases, of course, the consumer product company face, but the damages are small, and people aren't impacted at all. And class counsel will often put on experts to try to get at some average or aggregate damage, whether it's a diminution in value or the average cost of a repair to the product. And imperative, of course, for defendants to remember and to remind courts, as we regularly do, methodology for calculating damages is a separate question from existence of damages to every class member. But that inevitably devolves into a battle of the experts And so at this point, I'm going to hand this over to one of those experts and hand the presentation over to Dr. Strombaum. Doctor?
Thanks, Paul. So given my background, I'm going to approach this topic from the perspective of an economic expert. And I'm going to talk about three topics. First, I want to introduce some damages theories that we see in these consumer product litigations. I'm going to talk just briefly about an economist perspective on complex consumer goods and how provide sort of a framework that you can think about complex consumer goods within. And then I'm going to introduce briefly a couple of statistical techniques, Hedonic Regression and Conjoint Analysis, that we see applied in these types of cases, applied in order to value specific attributes of a complex good. So, next slide, please. So I think Michael did a good job in describing the evolution of the standards for class treatment. Just briefly echo that. Experts in class certifications at the class stage addressing issues that had previously been reserved for merits to the extent that they are important in determining whether the requirements of Rule 26 are met. In general, I think the expert's role in the class certification process at this stage has been expanded in the last 10 years as various laws, decisions have been evolved in this area. And particularly the focus of experts are on the issues of commonality and predominance. Slide, please. So yeah, I think the key questions fall really into three categories, just briefly. The commonality question, is there a common method of showing that all or nearly all of the members of the class were harmed? The issue. Secondly, the issue of individual inquiry. Is it possible with common facts to show injury or harm or liability to all members of the class, or is individual inquiry necessary to establish that? And thirdly, the general issues of reliance and loss causation. Is there a method of proving reliance or loss causation across members of the class, a common method? Frequently, the issue of reliance is one that's presumed, but it's a rebuttable presumption oftentimes. And so the question is whether that issue can be addressed in a common method that applies across all members of the class. Next slide, please. You know, in general, when we think of damages, the objective of paying damages is to return the plaintiffs to the economic position that they've been in, but for the alleged conduct of the defendants. And depending on the particular product or the defect involved, and also, I guess, the cause of action, can be different elements or different measures or different theories of damages in these consumer product litigation cases. They fit, I think, into three categories. First of all, are the incremental costs that a consumer may incur as a consequence of the defect. These may be kind of ongoing costs. For example, air conditioners with an alleged defect that causes more frequent servicing, or the use of more coolant may cause a consumer to incur kind of an ongoing stream of expense associated with the product they wouldn't have had absent the defect. Another example would be a defect that shortens the useful life of the product. If there's pure degradation of the product and it has to be replaced sooner, then there's an acceleration of the expenditure. Generally, some form of cost in this first category that's incurred due to the defect that wouldn't have been incurred otherwise. In some cases, the defect can be fixed, in which case a consumer may incur the cost to cure the defect. In which case, there's the of ongoing cost is eliminated and is replaced by a fixed one-time cost to repair or replace the defective product. Those types of expenditures, to the extent that there is a fix, kind of limit or place an upper bound on the damages that can be claimed because the defect can be remedied. These first two categories of damages theory are really kind of consequential or out-of-pocket damages. They turn on the experience of each class member, and the issue for an expert is whether there's commonality across the experience of the consumers. Are the used in the same way? Would they have been used in the same way but for the defect? And is there a common method of determining the amount of damage, if any, that's suffered across the disparate experiences of different consumers? Alternative to these kind of consequential or out-of-pocket damages is the idea of diminution in value. As Michael mentioned, this is attractive to plaintiffs for a number of reasons, in particular because the defect doesn't have to be manifest necessarily for a consumer in order for the consumer to have experienced a diminution in value of their product, of the experience with the product. So it broadens the number of individuals in the class if there is a way of demonstrating a diminution in the value of the product as a consequence of the defect. The issue here is from a methodological standpoint, is always how does one go about measuring the diminution in value. In some cases, if the defect is revealed at a particular point in time, you may be able to see an effect on prices for a new product that is known to have the defect. The consumers are willing to pay less. If there's a secondary market, used prices for used cars, for example, is an example where plaintiffs have attempted to show that as a defect became, as the public became aware of the defect, the value, depreciated value of the vehicle declined, and used car prices declined for that vehicle relative to comparable vehicles or relative to the historical value of those vehicles. But oftentimes from a legal standpoint, is this benefit of the bargain, which is not a value at some later point in time when a defect is revealed, but rather it's the question to be answered is what would the product sold for absent the defect versus what it sold for with the defect, So it becomes a question of determining what the purchase price would have been had the consumer been aware of the defect, and that's a difficult empirical question to answer oftentimes. But statistical techniques that have been applied to that. Please. Before jumping in that, let me step back just a brief second and talk about the economics of consumer goods and how economists think about complex consumer goods. There's a fair amount of economic theory that goes back many decades in which complex consumer goods are viewed as bundles of attributes or characteristics. So you buy, under this theory, consumers buy products because they embody certain attributes that they want, and different combinations of those attributes provide different levels of utility or different levels of pleasure to the consumer, and it's kind of the aggregate utility of the bundle that determines what a consumer is willing to pay for a particular product. Frequently, because the consumer is concerned about this entire bundle, it's not possible to observe the value that's placed on specific attributes that comprise the bundle. And that creates kind of a methodological problem when one of those attributes that may not be priced separately is the subject of a product defect litigation. So let me flip to the next slide, please. So just an example of this, in the case of vehicles, different consumers may value the different attributes differently. So, for example, air conditioning may be important to consumers A and B, but not so important to consumer C. The presence of a turbo may be important to some consumers, but others may actually consider it to be, a disbenefit in that there may be maintenance or greater fuel consumption or other undesirable characteristics, and on down the list of attributes. So in the end, the consumer evaluates all the different components of the product, determines the reservation price or kind of the net benefit of all the attributes, and compares that to the market price at which you can purchase the product, and makes a purchase decision or not. So in this case, consumer A values the bundle more than the market price, so would be willing to purchase the product, whereas consumers B and C value the attributes less than the market price and therefore would not be willing to purchase the product. Next slide, please. So this kind of suggests or lays the theoretical foundation for the technique of hedonic regression, which is essentially a method of valuing each of the individual attributes of a product. It derives from utility theory. The name hedonic regression comes from the similar root to hedonism. It's this idea of utility theory that consumers are out to maximize the pleasure that they receive or the utility that they receive. And there's a kind of theoretical underpinning to the hedonic regression that derives from that utility theory that economists like to talk about. So the basic model is described there in the first bullet, where the vehicle price, we're going to use an automobile as the example here. The vehicle price is a function of a bunch of different attributes. There may be some continuous attributes like miles per gallon that can take on values from 5 6 miles to a gallon up to 50 miles per gallon, so it's a continuous variable. This, for example, is a continuous variable. Maybe discrete attributes like the presence or absence of air conditioning or a turbocharger, or whether the vehicle is produced domestically or internationally. And then there are typically a bunch of other attributes that may or may not be actually measured explicitly in the model, but those standard and controlled for. And the final note, there's the disturbance term, which represents the variation in the price that can't be explained by the various attributes. These are other things that influence the price for which we may not have measures, or just random variation that occurs. So this is the basic model, and the result of the hedonic model is associate a price with each one of the attributes that are included in the model. So, for example, if we're thinking of a vehicle, in case that I worked on, the absence of a telematics system and a navigation system, which may not be priced separately, the hedonic regression may be able to provide an estimate of the average price for that feature, even though there's not a separate price that the consumer pays for the feature. Essentially, what's involved in estimating a model like that is just a bunch of observations on transactions. So a bunch of transaction prices and a bunch of attributes of the vehicle, which allow you to estimate a hedonic model. The issues of the hedonic model, it is an accepted scientific method. There's an academic literature that supports it. It's been used many times in peer-reviewed articles. And consequently, it can meet the requirements or the standards for Dalbert challenges. Of course, the issue is always in how the technique is applied in a particular circumstance, and it's not Dalbert proof, but it certainly can meet those standards. It involves actual transactions, so it has this advantage that it reflects actual prices that we observe in the marketplace. Allows this estimation of prices for attributes that aren't priced separately. And it does allow for controlling for other factors. So some simpler comparisons, benchmark comparisons, and other techniques will yield less precise estimates of the value of particular attributes, and so this hedonic method may be preferred to those simpler methods. Limitations, increasingly is at the class certification stage. It's not sufficient just to describe that you're going to use hedonic regressions, for example, but rather actually to have to estimate hedonic regressions, because there's some issues about whether a model can actually be estimated given the structure of the data, available data that exists out there. So, increasingly, the implementation of the model is required. It is data-intensive procedure, so you have to have a lot of information about a lot of transactions in order to try and apply this method. And many times the data may not be available, so that it's not an applicable technique. And then, of course, there are a lot of technical issues in applying the econometric technique, which I won't go into other than to say that just like any other sort of regression or statistical analysis, it's based on a lot of assumptions and conditions that have to be met in order for the result to be statistically valid and informative. Next slide, please. An important limitation relates to how plaintiffs sometimes attempt to use this technique. It's often offered as proof of common impact. So if the plaintiff's expert estimates a hedonic regression, claims that, for example, the thematic system has an average value of $400, that this proof of a common impact. In fact, it's not proof of a common impact. The model essentially assumes, rather than tests for a common impact, the effect that's measured is an average effect. It may or may not apply to all of the may or may not apply. Next slide, please. Here's an example of what can happen in estimating a hedonic model. The first bar there shows the average effect, which may be positive and statistically significant, but there may be subgroups in different geographies, between brands, or across different channels of distribution, for example, where the effect is not present. In closing, if we go to the next slide, just very briefly, conjoint analysis. This is a technique similar to hedonic regressions, but it relies upon sample and survey data. So rather than having to have a bunch of transaction data on specific product purchases, the information can be derived through sampling and survey techniques. And that's the general advantage of the technique, is that the data can be constructed through surveys rather than available through the case. The disadvantages are that the techniques really depend upon sampling and survey techniques, which are themselves can be criticized. And they're based upon the stated preferences and not actual transactions. So consumers can indicate how they value different groups of attributes, but they're making actual purchases, so that may be the subject of criticism. So I think that brings me to the conclusion of my contribution to this seminar, and I think at this point I'd like to just pass it on to Justice Robert Rivera-Soto.
Everyone, in the time that remains, I'm going to try to make this up to would be the following step, which would be what cases is filed, a class certification determination has been made, what then? At the start, we should start with a caveat, and that is all single plaintiff claims cases do exist. The significant cases that are pursued are as class actions. That's where we're going to focus. The question then arises, what happens if you have an adverse class certification decision? Now here you have to remember that Making that determination, the court has to determine both the four factors that exist under Rule 43A, which are numerosity, commonality, totality, and adequacy of representation, as well as the two factors that appear under Rule 23B, which is incompatibility and predominance. Now, once you've got a determination, whoever is the losing side on that class certification determination is presented with the quintessential, other than that, Mrs. Lincoln, how'd you like the play problem. Because to the plaintiff, the denial of class certification may very well be the end of the case, because it removes the incentive that the plaintiff's counsel has in prosecuting a class action case. Is no longer a class action case. It is now a single plaintiff case. And one has to recognize that in the vast majority of these cases, the client is plaintiff's counsel. The putative client, the named plaintiff, is really the vehicle by which the counsel is seeking to get fees. For the defendant, grant of class certification oftentimes is the beginning and end of the case, because at that point, all you're trying to determine if the certification is maintained is how much is this going to cost you, because the cost of trying the case are going to be fairly significant, not to mention the possibility of a fairly large verdict. You're confronted with your strategy and your choices. Well, is it better to pursue an interlocutory appeal, or is it better to continue within the trial court in the hope that maybe something will develop that will assist you in determining that class certification was in fact improper? Now, you need to look at this differently depending on whether you're in state or federal courts, and the states sort of vary from what the federal courts hold. But for ease, we'll talk about the rules because those are nationwide. Under Federal Rule of Civil Procedure 23F, an appeal from a class certification determination can be taken to the respective Circuit Court of Appeals. Remember, it's not an appeal as of right. It is a discretionary appeal. Now, the fact that it is a discretionary appeal may very well explain the statistics that Michael gave you earlier, where he explained that, the vast majority of the appeals that are taken by defendants from an order below granting class certification, and those that are in fact heard, the majority of those result in a reversal. The reason for that is fairly straightforward. As I mentioned before, generally the class certification determination is the end of the case. And so if class has been certified, then clearly that the defendant is going to take up, and that's what the appellate court is going to focus on, because if it determines that the class should not have been certified, that is the case. And if it determines that the class should have been certified, that should belong and stay in the trial court and reach its own timely death. Now, that said, one needs to remember that most state courts are not as familiar with class action rules as are the federal courts, and as a result, they tend to be very hesitant in making class action determinations one way or the other. So bear that in mind depending on the forum in which you are. Deciding that you're going to appeal all requires that you focus on whether this is the right case within which to appeal. And the first question, and to me always the threshold question, whether the issue is sufficiently developed in the trial court to provide an appropriate record the appellate court will look at. not a full enough record that's beneficial to you, and you've got no business taking that appeal. It is, and the trial judge just simply got it wrong, that you need to take that case up and an end to it. Now, the question of timing. Do you want a chance with firm findings, or do you want to wait until you have a fully developed record to do so? And I'll talk about that in a minute in respect of the hydrogen peroxide case. But assuming normal circumstances, that presents you with the question of be careful what you ask for, you might get it, because if you appeal a class certification grant and you don't have all of your ducks in a row, you'll be confronted with a law of the case determination that will foreclose you being able to make additional arguments later on as to why the class should not have been certified. Now, product cases themselves, certification issues that are often complicated, the interplay of the merits on the appeal. For example, merits discovery or even trial proofs can raise issues in respect of questions that are core to the certification. Was this an adequate plaintiff representative? Those kinds of things that may arise later. Now, when the Circuit decided in re hydrogen peroxide antitrust litigation, there was a fundamental shift how cases are being looked at, because up until that point, the class certification record tended to be a little more sparse than most defendants wanted and a little more fulsome than most plaintiffs wanted. Pride changed things. The Third Circuit confirmed that a court had to apply rigorous scrutiny to certification decisions, that are to weigh the evidence that is proffered in support or in opposition to a class certification application, and that might even include dog-type challenges to parties experts at the class certification stage. And those who may want to cabin the effect of peroxide to sleep the Third Circuit, bear in mind that the United States Supreme Court and the Walmart case cited to peroxide with approval. So it seems to have received the imprimatur of the Supreme Court. What's the result? Well, now courts making class certification decisions are going to be presented with a fuller record. They are to have far more on their plate than was previously the case. The flip side of that, of course, is that an appellate court with a more fulsome and robust record generally defer then to the trial court. Recall that on appeal, a trial court's factual findings are entitled to deference, whereas its legal findings are reviewed de novo. So, since all of this is driven by the facts, that's what's important. So, go back. What are you looking at when you're making your case for your appeal? Well, you start with just the pleadings and written discovery. In post-peroxide cases, you will have class representative depositions, experts. When you add all of that together, you have a fairly complete, or you should have, a fairly complete record upon which the trial court is going to be asked to make a class certification determination. What does it mean practically? It means that because a full class certification is required, will be a blurring the difference between what used to be class certification discovery and is everyday common variety merits discovery. That's the second edge of this sword, of the peroxide sword. You get more information, you get a fuller record, but it's to expand the scope of what used to be a fairly limited class certification record, and it creates what should be a more bulletproof record for appeal. The greater record will include information on testing and statistics that did not used to be part of the class cert record, greater consideration of advertising and marketing that did not used to be part of the old class cert record. There's more evidence in respect of absent class members, the phenomenon that Michael referred to earlier, and of course there's a greater scrutiny of the merits of expert opinions, something that didn't happen until after a certification decision was made, a Dauber challenge was presented. That in sum tells you what the appellate issues are in respect of these class cert decisions, and I see we have a couple of minutes left, which would then take us to questions that people may have. And I'm handing this back to Neil Walters.
Thanks, everyone. One of the questions we received, which we can handle right now, is where do you see the next wave of litigation arising and what types of products or claims? I think that we can predict that the prevalence of consumer electronics with the popularity of iPads, iPods, and whatever new technology will arise, the volume of claims is largely going to follow the prevalence of the product in the marketplace, particularly where you're dealing with sophistication, where a product is going to, its use is going to depend upon fairly sophisticated instructions, where there are opportunities in the marketing and advertising for detailed information either to be misconstrued or perhaps mistakenly provided. I think we will continue to see a prevalence of consumer class actions in the automotive context because the technology there continues to evolve. The NDL in the Eastern District of Michigan is a perfect example of that, albeit 8 to 10 years ago when vehicle telematics was a very new thing. It was very popular, but it was largely misunderstood as to how you were going to receive your signals. And of course, I think we're going to see no slowdown with pharmaceuticals or medical devices. That concludes our 1-hour presentation today. I'd like to thank our panelists for this interesting presentation. We received some other questions that we're going to respond to directly by email after the presentation. And I'd like to thank everyone for joining us